Art of Advocacy. I am often told by parents of children who they think will make very good lawyers, please take him or her in your chambers. He'll make a very good, or she will make a very good advocate. And I would say, oh really? Why is that so? Oh, he or she is very argumentative. Now, it's very difficult to explain to a loving parent that the worst part about being an advocate or being considered to be a good advocate would be the fact that you are argumentative. Because, as you know, our profession of being a good advocate is more about being a good listener and even more a good thinker. If I may borrow the words of Bruce Lee, the famous Kung Fu fighter, who described Kung Fu as the art of fighting without fighting. And if I were to apply it to our profession, advocacy is the art of arguing without arguing. So what is advocacy? Or what is the art of advocacy? For this, I would first like to read to you two passages which I found very interesting from a book written about one of the most eminent QCs, Jeremy Hutchinson. The book is called Jeremy Hutchinson's Case Histories by a gentleman called Mr. Thomas Grant, who is the author of the book. Jeremy practiced criminal law and was considered the leader of the criminal bar in London in the 60s, 70s and 80s, and later became a member of the House of Lords. What does he have to say about the art of advocacy? Let me read to you a passage, and it so aptly describes what we are here today to talk about. Advocacy, I think every word is important. Advocacy is the art of persuasive and attractive speech. Nowadays, the student must attend many hours of advocacy training. Indeed, the main remaining role of the Inns of Court now appears to be just that, the upholding of integrity. The upholding of integrity, duty to the court, the overwhelming importance of preparation, mastering the law and the facts can all be taught. But, as Lord Burkett once pointed out, how can one teach that skill that could win from the diarist John Aubrey, when speaking of Lord Chancellor Bacon, the comment, "It was the fear of all who heard him that he would make an end of from Pitt the younger when replying to an expression of surprise at the huge reputation of Charles James Fox when he said, 'Ah, but you have never been under the word of the magician. There lies the art of advocacy.'" Unquote. There is one more passage in the same book which is shorter and again very pithily summarizes what I want to talk to you about. And that says, like conversation or theatre, the essence of advocacy is the impression it makes at the moment it is given voice, to the immediate audience to whom it is made. The words themselves and the meanings they are intended to convey are only half of the effect. Put fine words, I am repeating this, put fine words into the mouth of a poor advocate, and those words can die on the tongue. Whereas a great advocate can conjure magic out of the proverbial laundry list, unquote. So this gives you a flavor of what art of advocacy is about. You can conjure magic out of a laundry list. I would also like to read to you another short passage from Fali Nariman's latest book called God Save the Honorable Supreme Court on advocacy and constitutional law. And the reason why I wanted to draw attention to this passage is because it tells us how advocacy is what is behind the development of our constitutional law. Let me read to you a short passage from this book which is written about Mr. Palkhiwala. And this is what it says, and I'm quoting, "It brings out India's constitutional history in the making. And it was in this struggle for the custody of the Constitution between Parliament and the court that the true art of superlative advocacy was witnessed. The struggle ultimately resulted in the establishment of the supremacy neither of Parliament nor of the court, but of the Constitution itself. This was accomplished through an innovative doctrine now known as the basic structure of the Constitution." So this gives you a flavor how advocacy can play a huge role in the development of the law itself, whether it be constitutional law or any other form of law which you practice. As juniors who are fortunate to be part of my chambers, and some of them are here today, would tell you what you see in court is only 1/10 of what really goes on in an advocate's life. As Biren mentioned, advocacy in court is virtually the last mile. It's really the 9/10 of the effort that goes in the chambers where you sit and you dissect and you bisect and you trisect and you look at every single angle. You call for the law, you look at the facts, you anticipate what the other side may argue, you anticipate what the judge may ask, you rule out what you think will not sell, you accept from the team that you may be leading some good argument, some good thought, some facts, and you put it all together. That is really where the real work is done. For an outsider, for a stranger, for a person who's visiting, for a person who may happen to be in court, when he hears an attractive argument, he may even go back thinking, so what was so great? But obviously that's because that person doesn't know that to make that last mile argument, there is so much that has gone behind it. There is so much of picking and there is so much of discarding that takes place, which an outsider would never ever see or never know. That is also part of the art of advocacy. Now, there is always a difference between lawyering and advocacy. Lawyering is nothing but applying a set of facts, taking a set of facts and applying the law to it, whether it be a particular document or it be a pleading. Advocacy is something which takes those facts and the law to a different level altogether. It begins where lawyering ends. So really speaking, it's the next level. And that is where your ingenuity comes in as an advocate. I often give the example to people that in a case, don't forget the fact that the same brief which you have read has been read by the entirety of the other side, because there are no surprises here. The same law which you may have studied and you may have researched is going to be researched by the other side. The same brief would have been read by your team, your clients, your juniors, your solicitors, and what have you. And yet, it is going to be that one person who is going to make the difference to winning and losing. And that is because advocacy is not written into the brief. Advocacy is what is outside the brief. And that is where your ingenuity, your thinking, your application of mind as an advocate will come into play. Masterful oratory is only one part of an advocate's skill. So don't ever miss the wood for the trees, if I may put it that way. Oh, he's a good orator, he's a good speaker, he's a good command over the language, he's a good knowledge of English. All that is fine, but that's only one part of the skill set. Advocacy comprises a multifarious levels of skill. It is not just the art of speaking. It starts essentially from something as basic as drafting, pleading, your ability to research, logical thinking, problem solving, how to lead evidence, how to cross-examine, and ultimately persuasive arguments. Why is that so? Because ultimately an advocate is a salesman of thoughts and ideas. If he is going to sell a thought or he wants to sell an idea, he wants to sell his client's case to the judge, it doesn't start with the brief coming into your hand and you are being told go and argue it. It starts with drafting. And my father always told me when I was a junior and briefless, you must learn to draft. Drafting is the way out. Drafting is the only way you can learn how to be a good advocate. Of course, easier said than done. Who's going to give me a drafting brief? I mean, I had no work in those days. So I would tell me, yeah, Dad, as in when somebody thinks I'm worthy of drafting, I will take it up. But there was a lot of sense in what he told me as I discovered later. Why? Because drafting of a pleading is the foundation of the entire case. If the foundation is weak, the superstructure can never stand. So when you talk of drafting, why is it so important, besides the fact that it is the foundation, and why it is an important part of an advocate's skill set? It is because it makes you sit down and think before you put pen to paper, and nowadays of course put fingers to computers. You have to, in those days we didn't have the benefit of computers and laptops and whatever. So we used to get these stenos who would be sent by a solicitor to your chamber, and invariably the solicitor would only spare the worst of the lot to you. So he would come in order to take dictation, and invariably you got a draft which you never dictated. So you went through the whole trouble in those days when you were as it is quite unsure of what you were saying, to find a draft which made no sense. And however much you told the steno that please make only 1 + 1, which is one copy plus another, one original plus a copy, he would make 1 + 3 and promptly send it to the solicitor concerned, so that it would ensure that you never got a second drafting brief in your career again. And there were times when we had solicitor stenos who were very ingenious in their ways. They would come and take dictation in shorthand, but they wouldn't type it out. They would farm it out to other people. So invariably, even if you got a draft which was not yours, at least there would be a semblance of what you had dictated. But can you imagine a shorthand typist a shorthand stenographer giving his shorthand notebook to somebody else, and then you get your draft back. I mean, there was absolutely no connection between what you wanted to do and what came back to you. So you all are much better off. You can correct your own mistakes, you can retype and rechange and all that, but we didn't have those luxuries. So, but the point I was making was, it helped you to streamline your thoughts. Why do you need that? Because when you are arguing, the more your thoughts are streamlined, the more logical they are, the more simplistic you make your argument, which you can only do if you have mastered the facts and mastered the law. Only then can you deliver. Drafting helps you to streamline. Why? I'll tell you. Firstly, the first thing when you are drafting something is, you will look at who will be the parties to the pleading, to the case. That itself will tell you what will the reliefs be. Because if you don't first concentrate on who are going to be the parties to your case, you will not know what reliefs you are going to ask for. If you have decided to start at the other end and say, my client wants to file so-and-so case for these reliefs, you will have to come back to the first question. If I need these reliefs, who will I ask or seek those reliefs against or from? So in a way, it makes you think who will be the parties, what will be the relief. And then you think of the cause of action, which will come in between after you've narrated the facts. I'll tell you an interesting story. I used to do a lot of drafting later when I was able to master the stenographers who wanted to destroy my career and get over that hurdle. Suresh Parekh was a master strategist. I don't know how many of you ever had the opportunity of working with him, but I can tell you, if you haven't, you missed something. He was par excellence. And my drafts, some of them very, very lengthy ones, used to go to him for settling. And do you know how he would settle the draft? He would call you in and say, "You've done this? Okay. What is this about?" By and large, you tell him this. Okay. Let us see your prayers. He'll run through the prayers. Okay. Now let's see who are the parties. He'll turn and see. Okay. Fine. Okay. So let me tell you. Your cause of action must be A, B, C and D. Have you got them in? If you say yes, without hesitation he would say settled by S.D. Parekh and give the draft back. He would know that if these were the parties and this was the relief, this had to be the causes of action and there cannot be anything more. And he would be with confidence, he would put his signature to that draft and say settle. That is the level to which advocacy can take you if once you master your thinking process, once you streamline your thinking process, once you have it all in. And it only comes with experience. Let me tell you, this is not magic. When I joined the bar and I gave you the names of all the greats, I used to tell myself, you are in the wrong place, you come at the wrong time, and you should turn your back and get out of this place before you make a fool of yourself. But let me tell you, because I used to see my own senior, Mr. Chagla, dictating drafts, where he had this habit of playing with his mustache, sometimes smoking his pipe, and the words would just flow so freely and so easily. And it made it look like magic. It looked like, how can you ever reach those levels? How can you ever, be so clear thinking? But I can tell you, it requires only experience. You have to just have the ability to stick it out. You have to give it time. This is not found in the law degrees, it's not found in the law colleges, it's not found in the law books. It only comes with experience. And these are some of the things which I am telling you are very general, but they are the skill sets which go a long way to developing your skills and your art of being a good advocate. One of the advices which I got when I joined the chambers of Iqbal Chagla, because Mr. Nariman used to be there at that time, and this is very, very interesting for many of us who don't do trials anymore. But in those days, virtually every suit that was drafted or every plaint that was drafted invariably went to trial. So you had to, in other words, devise your plaint, your cause of action and everything with the idea that if this goes to trial tomorrow, is this case good to go to a final hearing? So what did Mr. Nariman tell us? Don't waste your time starting the plaint. You get hold of the witnesses, get hold of the client, dictate his proofs. Who's going to give evidence? You dictate his proofs. Make his evidence first. Lock it up. Tell the solicitor to put it in a safe. And then you draft the plaint. And I tell you, these are golden words. These are golden words. Because invariably, when those matters went to trial, where the proofs may not have been dictated, where the evidence would not have been taken in advance, clients have gone into the box in our presence and said, I said this only because my lawyer told me to say so. So this is what was something we were taught in those days. And I have adopted it in a different way because unfortunately we don't reach trial in, at least I don't know last time I conducted one in the High Court, but and we don't reach those stages anymore. But I'll tell you one thing, and this is something which you must bear in mind. At least what we do nowadays is the drafting of a lot of affidavits or settling of affidavits drafted by somebody else. I can only give you one piece of advice. Never, ever dictate a pleading or an affidavit in the absence of the deponent. Please don't do it. It's the worst thing you can do to yourself. It is not professional, it is not right, and you can never, ever imagine the facts. Please do not take it for granted that what you have been told by your solicitor are the facts. Please don't take it for granted that somebody other than the deponent telling you what are the facts are the facts. And I don't need to give you examples, but I can rattle off at least 1 dozen without batting an eyelid when I have myself seen that when the deponent has come and when I have asked him, is this what you want to say or is this what is your case? And invariably I have been told, no, it is not, these are the facts. And the whole matter has turned based on what was the correct factual position. So I urge you people not to make this mistake. A Calcutta senior counsel was asked, if you had to describe this profession in one word, would you be able to do it? And without batting